Thank you for the invitation to testify at this timely and important hearing. My name is Devlin Hartline, and I'm a legal fellow at the Hudson Institute's Forum for Intellectual Property. I'd like to start with the question posed by the title of this hearing: is there a right to repair? And the answer is clearly no. A right is a legally enforceable claim against another, but the courts have not recognized that manufacturers have the duty to help consumers make repairs. Instead, the courts have said that while we have the ability to repair our things, we also have the duty not to infringe the IP rights in the process. So it is in fact the manufacturers who have the relevant rights, not consumers. Right to repair supporters want lawmakers to force manufacturers to make the tools, parts, and know-how needed to facilitate repairs available to consumers and independent repair shops. And the assumption here is that anything standing in the way of repair opportunities must necessarily harm the public good. But these tools, parts, and know-how are often protected by IP rights, such as copyrights and design patents. And we protect copyrighted works and patented inventions because, as the Constitution recognizes, this promotes the public good. We reward creators and innovators as an incentive for them to bring these things to the marketplace, and the public benefits from the introduction of new products and services that increase competition. Thus, the right to repair movement isn't based on a pre-existing right. It's instead asking lawmakers to create a new right at the expense of the existing rights of IP owners. And there have been several bills introduced at the federal level, and they generally take one of two approaches. So the first is to rewrite the Copyright Act or the Patent Act in a way that directly limits IP rights. So this is the approach with the SMART Act and the Freedom to Repair Act. The second approach is to define the normal exercise of IP rights as an unfair or deceptive practice to be enforced by the FTC. This is the Repair Act and the Fair Repair Act. Of course, the FTC already has the authority to address unfair or deceptive trade practices. And it's noteworthy that even after promising to crack down on this 2 years ago, the FTC has not brought such an enforcement action against a manufacturer, though it has brought a few actions related to warranties. So I submit that the reason for this is simple. IP owners are merely exercising their federally protected IP rights, and this is not actionable anti-competitive conduct. It is instead how the IP system is supposed to work. We grant IP owners exclusive rights so they can exclude others. And this in turn promotes the investments to create and to commercialize these creative innovations in the marketplace. And that promotes the public good. And as tempting as it may be to take away or limit IP rights so that others can copy and then call that competition, I would urge the members to think about whether that truly represents sound economic policy. The fact that the definition of unfair or deceptive practices would have to be changed shows that it's not really a competition law problem. I would recommend against micromanaging the free market system to pick winners and losers. The market does a great job of sorting this out already. And with that, I again thank you for the invitation to speak today.
Thank you. Please.
Chairman Issa, Ranking Member Johnson, and members of the subcommittee, thank you for the opportunity to speak with you all today. My name is Perzanowski. I am a professor of law at the University of Michigan, and for the last 15 years, my academic research has focused on the intersection of personal and intellectual property rights in the digital economy. During that time, the right to repair has emerged as a central challenge to the notion that we as consumers control the devices that we buy. Instead, consumers, farmers, small businesses all find that manufacturers exert post-sale control over these devices, often in ways that frustrate repair. Repair is as old as humanity. Our Paleolithic ancestors repaired hand axes and other primitive tools. And as our technologies have grown more complex, from the Bronze Age through the Renaissance to the high-tech devices that we all have in our pockets here today, repair has always kept pace. But today, manufacturers are employing a range of strategies that restrict repair, from their hardware and software design choices to clampdowns on secondary markets. And we also troublingly see attempts to leverage IP rights as tools to restrict repair. These efforts are a major departure from the historical treatment of repair under the law. The right to repair is not only consistent with nearly 2 centuries of IP law in the United States, it reflects half a millennium of common law property doctrine that rejects post-sale restrictions on personal property. As early as the 15th century, English property law recognized that once a property owner sells an item, efforts to restrain how the new owner of that item can use it are inconsistent with the essential nature of private property and obnoxious to public policy. As the Supreme Court has repeatedly recognized, IP law's respect for the property interests of purchasers of copyrighted and patented goods was profoundly shaped by this common law tradition. In 1850, the Supreme Court recognized that the repair of a patented machine reflected, quote, no more than the exercise of that right of care which everyone may use to give duration to that which he owns. A century later, the court held that the repair of a convertible car roof was justified as an exercise of, quote, the lawful right of the property owner to repair his property. And just a few years ago, the court reaffirmed the rejection of post-sale restrictions under patent law in Impression Products versus Lexmark, a case about refurbishing printer ink cartridges. Copyright law, not surprisingly, has had fewer occasions to consider repair restrictions, but as early as 1901, the Seventh Circuit recognized, quote, a right of repair or renewal under US copyright law. When a publisher sued to prevent a used book dealer from repairing and replacing damaged components of books, the court said that, quote, the right of ownership in the book carries with it and includes the right to maintain the book as nearly as possible in its original condition. A century after that, Congress itself acknowledged repair as a right that owners enjoy regardless of copyright restrictions when it enacted Section 117C of the Copyright Act. That provision was designed to undo a Ninth Circuit decision that allowed copyright holders to prevent third-party repairs of computers. Section 117C explicitly permits owners of machines to make copies of computer programs in the course of maintenance or repair. And finally, the US Copyright Office over the last decade has repeatedly concluded that diagnosis, repair, and maintenance activities are non-infringing when it comes to vehicles, consumer devices, and medical equipment. So the right to repair is firmly rooted in basic principles of US IP law. But IP law can and does continue to interfere with repair. Kyle talked about overbroad copyright claims over service manuals that limit access to crucial information. Section 1201 of the DMCA makes it practically impossible for consumers to exercise their lawful right to repair a wide range of devices, from tractors to home electronics, even though the Copyright Office says those activities are non-infringing. And the weakening of standards for design patents allow firms to choke off the supply of replacement parts needed to repair vehicles, home appliances, and other devices. So I thank you all for your interest and your leadership on this issue, and I'm looking forward to your questions.